Hi, everyone. Welcome to episode 196 of the Immigration Lawyers Podcast. Today, we're doing our monthly with Kevin Gregg, talking about recent federal court and BIA decisions with regard to litigation. And he's the expert on that. He has this great show, Immigration Review, which you can find on everywhere podcasts are shown. I definitely recommend doing that. Before I start, I want to remind everybody that the second issue of the Immigration Lawyers Toolbox magazine is out. Just go to immigrationlawyerstoolbox.com/magazine, download it. Tons of information in there. I think you'll really enjoy it. Contributors were wonderful. I want to thank the sponsors that took part in that as well. Visa Business Plans, FIS Web, ILRC, and in particular DocuWise. DocuWise is the immigration form and management software. If you go to DocuWise.com/immigration-lawyers-podcast, you could get a 10% additional off their annual plan. Just go to, again, that's DocuWise.com/immigration-lawyers-podcast, and the code is Immigration Lawyers Podcast. So I think you'll really enjoy that. Well, with that, let's get it started. Hey Greg, Kevin, how are you doing? St. Greg, I know you for a while. St. Greg.
I used to work for judges who, after like 2 years, one called me Greg once. I'm like, I mean, come on, Judge. Like, we work very, very closely together. Like, I think it's just something happens in the brain. I'm doing great.
It triggers it, yeah.
But if I'm Greg, that makes my last name Kevin, so that's much worse. I'm doing great, John. How are you?
Good. Just we were talking a little bit, just the stuff with USCIS going back and forth, and I just got a Venezuelan TPS case, and I hadn't done TPS in a long time, so I'm like going through the checklist and stuff, make sure I'm not missing anything. But it seems pretty straightforward.
Yeah, no, I mean, famous last words. Congratulations on your second issue of the magazine, by the way.
I appreciate it. Yeah, it's been a joyful ride. Now we're already prepping for number 3. It's going to be a special one just focused on ONAs. So it'll be cool. It's going to be everyone getting into immigration law from now in the future is like going to find these magazines and be like, oh wow, like there's like treasure right here for free. So I think it's a real neat thing for the community.
It's awesome, man. Congrats.
So what's going on in the litigation world and federal world?
Well, the district court stuff seems to have significantly lessened. With the prior administration not trying to nuke everything that is immigration, it seems like there's less district court lawsuits, which make all of our lives easier. But it's only been a couple of months with the Biden administration, and they've done a lot of good things. And I'm sure that they got stuff in the works. I know you've probably seen that report with the New York Times that Secretary Mayorkas is planning to do a bunch of stuff in the coming months.
Mm-hmm.
But in these presidential decisions that I read every day, I just finished reading one. A lot of courts are starting to footnote the new regulations in various contexts that were pushed through at the end of the Trump administration, and that I could have sworn were all enjoined or stayed, but I don't know. There's an AILA website that that says that lists all the status of all the new regulations. And I reviewed it. It's in the links to one of my immigration review episodes of a couple times ago. I could have sworn they were all stayed, but the circuits don't seem to think so. Wow. And I don't know what it takes and I don't know what Secretary Mayorkas, President Biden plan to do with some of these regs, but I mean, they are killer regs. I mean, the immigration community is calling the death to asylum reg and the death to motions to reopen regs. I mean, I don't think it's hyperbole. So I hope the administration can do it, because sooner or later, the regs will become applicable to a case before the circuit. It takes a couple of months or years because, the reg has to be in effect at the time it goes before at least the BIA for it to be at issue before the circuit. But like, the footnotes are getting dropped. It's kind of like the first shots across the bow, and God help us if we're litigating these cases going forward with those 11th hour regs that were pushed through by the prior administration.
Oh man, I read a headline today too that Texas and a couple other states have sued about the public charge rule, and one court said USCIS can't close the case; it still has to go forward or something like that. Which I was surprised because the administration made the switch.
I don't know about that. I mean, I didn't read that. It very well might be true. I thought the public charge thing was dead. I thought that the courts found they lacked standing, but I don't know.
I thought the court said that's done for, and then some other court said no. USCIS still has to go through the case or something like that. I was like, well, that doesn't make any sense. But I didn't read too much into it. We're still post NIS case. We're seeing how that's going to play out, and the courts. I mean, is EOIR are they fully operational, or is it still like partially operational depending on the location?
I think it's partially operational. They're still depend on the courts, but like the Miami court, they're not bringing all of their judges in every week. I mean, New York, it appears, just opened up last week. I don't think that they're fully at San Diego, where I am. They have special schedules, so they're still opening up with that. And you mentioned the Niz Chavez case. I mean, I figured that this week, and I'll do it quickly. I would just talk Supreme Court, and then there's one 11th Circuit case that's just a monster that needs to be discussed. But there's 3 Supreme Court cases since you and I last spoke, and that's rarely the case.
Yeah,
Supreme Court's always important. 2 good, 1 good, 2 bad for non-citizens, but those 2 bads are in the 9th Circuit, where you and I both are, so very, very important. Niz Chavez, as you mentioned, everyone knows in the immigration removal community, it's about whether or not the stop time rule after Pereira v. Sessions for non-LPR cancellation of removal gets triggered, notwithstanding a non-compliant notice to appear, when the immigration court sends a notice of hearing, as almost always happens a couple of months later. Supreme Court, Pereira, which was 2018, was near unanimous. Only Justice Alito dissented. This time, I believe Justice Barrett did not partake, and it was therefore no, Justice Barrett did partake. It was 6-3. So I'm sorry. Let me get it right for everybody.
Don't take your time.
No, it looks like Justice Gorsuch was joined by Justice Thomas and Justice Barrett, and then the historically liberal wing. So still majority, with Justice Alito, Kavanaugh, and Roberts in dissent, saying that no, the stop time rule, Pereira said what it meant. The stop time rule is only implicated. The 10 years required of non-LPR cancellation only stops if served with a statutory compliant notice to appear that has the date and time, location of the first removal hearing. A notice of hearing does not implicate the stop time rule. So that's big. It overturns some circuit precedent, agrees with other circuit case law after Pereira, overturns the board in Mendoza, Hernandez, and Capullo-Cortez. Big case. On all fours with non-LPR cancellation, as I said on the podcast, what it means for motions to reopen and just jurisdiction in general for removal proceedings needs to play itself out. But at a minimum, I think that there's a very strong argument for motions to reopen where an individual was denied cancellation of removal or didn't apply for cancellation of removal solely because of a stop time rule issue based on a non-compliant NTA. What happens if their qualifying relatives have aged out? It's going to have to get really creative, which might be the case, but certainly huge for individuals currently in removal proceedings, very big for motions to reopen, and I'm sure we'll be seeing cases for years to come on Niz Chavez.
And there's some bomb shows. You might not even got some in your own podcast, but popped up. One was a 9th Circuit one. The Supreme Court just threw out the window about, you know what I'm talking about, right? The silent credibility test.
Well, I was gonna get to that in a second. Actually,
right.
That'll be discussed in this week's podcast. But actually, before that, the first 9th Circuit one was United States v. Palomar Santiago. It was in the criminal context. It's another case where the Supreme Court unanimously threw out a 9th Circuit rule with illegal reentry convictions. And it essentially used to be the case, apparently, in the 9th Circuit that if since the individual was removed, they're no longer removable. In this case, based on the Supreme Court's Leocal decision, in which the Supreme Court held after this individual's removal that aggravated DUI was no longer an aggravated felony. Or you can think about the Maya, maybe if someone was removed for a crime of violence under 16B, which, no longer exists. It's unconstitutional because of the DeMaia v. Sessions case, something like that. If they are removed on a ground that is then no longer good law based on Supreme Court or even circuit precedent, in the 9th Circuit, you couldn't be convicted because conviction based on that removal order would be fundamentally unfair. At least in circumstances where, say, the Supreme Court says the statute never meant that. That was wrong back then. Unanimous Supreme Court in this Palomar Santiago case said no, non-citizen must exhaust all their administrative remedies, which essentially means that before they got deported, they needed to file an appeal with the board, and they needed to file a petition for review in their circuit. So I think that might have been what was required in most circuits, but that was not what was required in the Ninth Circuit. And so pretty bad for criminal defense attorneys who do illegal reentries in the Ninth Circuit, and important to know as an immigration attorney as well. You got to exhaust your stuff. And then you mentioned Garland v. Dye. That just came out. Haven't discussed it on the podcast yet. We'll talk about it on Monday. But again, not another unanimous Supreme Court overturning the Ninth Circuit. Essentially, the Ninth Circuit had a rule that if an immigration judge does not make an express adverse credibility finding, doesn't say, I find you adversely credible. If the immigration judge doesn't do that, the non-citizen must be deemed credible on appeal to the board, and then before the Ninth Circuit, deemed credible. Even if the immigration judge says, I don't really believe what you're saying, and there's a flaw here, there's a flaw there. If they don't expressly say, I make an adverse credibility finding, you have to deem them credible on petition for review. And, you know, I used to work for immigration judges. It's hard to make an adverse credibility decision, especially in the Ninth Circuit. And so I can understand why immigration judges sometimes don't want to do that, but the statute requires that it be done. I mean, that's why we have adverse credibility. But it was changed by the Real ID Act, and now an immigration judge can find less than adversely credible testimony not persuasive, for example. I mean, it's complicated stuff, as you know. In this case, Garland v. Dye, Supreme Court overturned the Ninth Circuit's rule that you had to deem the non-citizen credible on petition for review. That's not the case anymore. It's just regular substantial evidence review. Are the factual findings from the board for why this non-citizen does not deserve relief, which is always the context this is happening, are those factual findings supported by substantial evidence? But it is interesting, though, because apparently under the statute, and I need to look more into it, but apparently on the statute, before the board, there is a presumption of credibility. Mm-hmm. So that presumption of credibility, it would appear, and again, I got to look at the statute, that does exist on appeal to the BIA. But if the BIA then says they have, if the BIA then says DHS overcame the presumption of credibility on appeal, or even if they imply it, which is what Justice Gorsuch seems to be saying, if the BIA says that or implicitly says that, there is no presumption of credibility on petition for review. So really, this case was about petition for review standards, not Board of Immigration Appeals standards.
Mm-hmm. But they say it. A lot of times they just need to say it and then without backing it up. The standards are much lower for them, but it just makes it tougher for these kind of situations.
It does make it tougher, and you really have to have tight testimony. You have to prepare your client. You have to explain when they get cross-examined by DHS. I mean, I think DHS is very good at cross-examining most trial attorneys. I myself have been cross-examined by DHS trial attorneys in a seminar on a fact pattern that I created. And I started sounding not credible. I was getting really pissed off too. Like, what are you talking about? Like, this is a made up fact pattern that I made up, and they managed to undercut me. So it is what they are good at doing. And you really have to be able to rehabilitate your client.
It's a problem with the silent, both an affirmative and the defensive position of it. That people who are credible could easily be knocked off, where they are just by the line of questioning, all the emotional baggage it's into it. So it's just so hard to really make a determination of either factual or truth or adverse their line, because people could have all sorts of tells. There's social aspects to it. There's just so much. Ideally, you'd focus on having good documentation, but as you know, like, these cases don't have documentation many times. So it just is such a hard thing to do in general, to just prove your case and go into it, let alone all the standards and connections and whatever the double pronged standard for silence, all that kind of stuff. It's just it's just a hard case to deal with. It's one of the reasons I don't work silent cases anymore. Too emotional and too much going on there. It's
really hard, and you got to prepare your client. But it is really hard. But adverse credibility is in the INA. a pillar of all of this. Immigration judges are supposed to make them. And I think that if it all gets too cute and they stop making them and we're all inferring this and that, and I think that the case law will right itself there, that maybe I'm being too optimistic. And again, the Supreme Court sent it back to the Ninth Circuit, I think, to tell us all, okay, what does the BIA need to do to hold that the non-citizen overcame the presumption of credibility? I mean, it's a presumption of credibility. There have to be a reason that you are overcoming the presumption of credibility on appeal if an immigration judge doesn't make an adverse credibility finding. So it's not nothing. We'll see how the case law plays itself out.
I mean, does it technically create a lot more work for the judge to do that? Is it more paperwork? Is that something that's, the facility?
I think the Supreme Court decision makes it easier for an immigration judge to deny cases and still get affirmed on appeal, assuming the immigration judge even cares about whether they get overturned at the BIA. I mean, I know IJs who don't care one way or the other. I think I personally would care, but I think this makes it easier. If you don't have to do an adverse credibility decision as an immigration judge and you want to deny a case, your life is easier. That's just a fact. It's hard to do in any circuit.
I hear you.
Easier after the Real ID Act. That's the point of the Real ID Act.
Is there anything good in the Real ID Act? Every time I run into it, it's always a headache for me as an immigration lawyer, the Real ID Act.
Well, we have nice, cool, driver's licenses.
They federalize the driver's license procedure. Step towards destroying decentralization in the federal system. Yeah, so that's that. One thing that popped up is like a side news thing is a technology company called CladGen admitted to H-1B visa fraud, so Justice Department cracked down on them. And you see this, it's a completely different topic, but federal prosecutors going after a lot of this H-1B fraud kind of stuff. So I had a call from a woman a couple weeks back who was doing OPT, and all her friends are doing OPT at this one company that would just like sign up at anybody just to do, just to take care of the paperwork for OPT purposes, but wasn't really doing the job. And she's like, everyone was doing it, so they just told me to do it as a normal thing, and they got busted, which led to all the go back to all the people who did OPT there get hit. So I wish a lot of times the F1s, it's hard to get people to know what to do and not to do before it's too late. But this kind of fraud, H-1B, OPT stuff exists, and people got to be really mindful of it. It can always pop up. I mean, you could be doing a marriage case that's above board, and all of a sudden, some history pops up where someone was on an H-1B and then they got married. Well, that fraud could come back and haunt them. So it's a mess.
Yeah, I don't want to promote Kurzban firm, but we are involved heavily in a lot of those, and a lot of the students we're taking advantage of. I mean, there was the Fine Dream scandal. That's a recent one. That individual's a primarily Chinese one, and that individual went to jail. There was the UNNJ case in which we represent the individuals in federal court. We got a published win at the Third Circuit on jurisdiction. The University of Northern New Jersey was a fake school, and I don't want to get into the discovery on it. I'm not even sure what's privileged and what's not, but I mean, the U.S. government was stringing these students along, making them seem like it was a legit school, and that doesn't always happen. That did happen in the UNNJ case. So they got to be careful, and our firm's got a lot of experience, and I've seen a lot of it. I mean, some F1, some students are more culpable than others, but I've lived abroad before as well. It's very hard to be in another country, a foreign country, and to know what's right and what's not. I sympathize. It's hard stuff.
Yeah, I was reading the Ombudsman's report too, and for the number of officers ICE has per school for CBIS, it's like one officer. We lost Kevin will come back in a sec, but just to keep it going, there's like one officer in charge of a CBIS record for like 500. I can't remember the stat, but it's some ridiculous number, like 150 schools get one person. So yeah, Greg, Kevin, I was talking about like a Ombudsman report said for each of these schools that have a ICE officer that's supposed to be part of the CBIS system to watch out for them, there's like 150 schools per officer. Something's ridiculous where and my number's completely off probably, but it was some ridiculous number where it's impossible for them to even oversee. So these schools are all over the place, even legit ones, over how well they do the documentation. A lot of times the schools will the student will go saying they want to do CPT, and then the school is like, okay, go and do it, but they don't update the I-20, they don't put in CVIS, and all of a sudden the student automatically violates because they did an internship and the school wasn't even paying attention. So these are like the stuff I see a lot happens, and it's really frustrating. These poor students don't know what's going on. They're just here trying to figure out. They're 18, 19, 20, they're kids, so they don't know what's going on, and just listening to the adults in the room.
Yeah, I mean, we don't want fraud, but at the same time, we want really high caliber student. I had to turn away a client a couple of weeks ago who fell out of status. She's like a double PhD. Like, we want this person in America, and I can't remember all the facts, but there was really nothing we could do. We could try to reinstate. It was going to cost a lot of money. We were going to probably fail. And she said, forget that. I'm going to a country that wants me. And that's obvious. No one would agree that just because in the middle of her thesis defense, she forgot to file her paperwork. I mean, that's nuts. So there's something's wrong there. There's a fine line between preventing fraud and retaining amazing international talent.
And it's so easy to fall out of it. For OPT, you have to file the OPT I-765 within 30 days of the I-20. You're 1 day off, you're out, and that catches people. Just people sometimes send the documents in the wrong place. You're missing this or that, and it's just. Or one thing is people do digital signatures for the I-765 for OPT because they don't know that, and then they're like, it gets bounced back because it's not a leak signature, even if it's a copy. So this stuff. It's hard to get litigation going because finding the plaintiffs is hard, all that kind of stuff. But it's definitely it's such a horrible thing to put these students through, especially because how much value they bring to the country. Before we get off the cases, there's just one more thing. And again, I feel like sometimes I talk too negative about the circuit cases. There's a lot of wins, but the negative ones are sometimes more interesting. And I must note, I start off with Ms. Chavez, which is a clear win with a lot of great language from Justice Gorsuch about how cumbersome immigration agencies are. But I got to talk about briefly Islam v. DHS, which I just love the case name, out of the 11th Circuit a couple of weeks ago. Mr. Islam, so it's not the religion. From Bangladesh. I mean, essentially, this case held that the BNP, the Bangladeshi Nationalist Party, which is the largest or second largest political party in all of Bangladesh and has been for 40 years, is a tier 3 terrorist organization. And that if you're a member and then presumably if you materially support it, you're barred as a terrorist. And not only that, there's strong language to indicate that the second largest or the other party, whatever it is, the Awami League, also a terrorist organization. They didn't come out and say it, but Mr. Islam himself got asylum in the U.S. because he feared the Awami League. And then when he went to adjust, they held that actually his political party, of which we, United States, gave you asylum, we actually think that's a terrorist organization. If that's true, it's like 160 million people in Bangladesh. I mean, they're all terrorists? Because you got to imagine that 75% of them have affiliations with one of these political parties. It seems crazy. It seems that if we were real, and at a minimum, we're talking millions of people. It seems like if we were going to make millions of people terrorist barred, it would be something Congress would do. Well-written decision. Don't get me wrong. Judge Jordan wrote it. It's the terrorism bar. It's the tier 3 framework that is very expansive and broad that Congress wrote. I mean, got to protect our country from terrorism, no doubt. But there are things in the material support and in the tier 3 terrorist organization framework that potentially lead to the exclusion of 160 million Bangladeshis. And that seems a bit extreme to me. Yeah, I'm glad you mentioned this because, I interact with Bangladeshi cases for E2 visas usually, but it wouldn't have even popped up in my mind for this. And if they have the money to invest, they may be connected with a political party from a country like that some way. So I just add an additional question. When you have a Bangladeshi case, ask them about political affiliations, and that could be an issue. I've been dealing with the tier 3 stuff with Iran, with the IRGC stuff for a while now, but that's really good to know. I'm glad you brought this up. Don't file on the 11th. Would it just be up to the 11th, or who made the terrorism designation? Was it DOS or like USCIS when he tried to adjust status from asylee to the special adjustment under 209 of the Act, and it was before USCIS, and then actually they sued in federal court, and that's how it made its way up to the 11th. So
USCIS did make the determination, but based on nothing more than their interpretation. Now it's binding law in the 11th Circuit. Whether USCIS and other circuits is going to do whatever the Miami or Atlanta, whatever office did that, I think it was the Miami office, whether the USCIS and other offices are going to do what the Miami office did. But I know colloquially that the IJs in Miami, a lot of them were not, this BNP issue has been out for a long time. IJs weren't making a terrorism finding. A lot of in Miami or in a lot of places, I've spoken to USCIS officers off the record. A lot of them weren't making this finding before, but now you have a published case. It's hard. It's a published case from the 11th Circuit. Certainly don't file in the 11th.
Wow. And it's just the nuances of immigration. You think you have an easy adjustment case, and this pops up on you.
Boom, terrorism.
Going back a full circle to the beginning about the TPS case I talked about, it's just famous last words. I'm waiting because. It's a Venezuelan case. Venezuela, a lot of times they have dual citizenship and stuff. So this case doesn't, but I just want to double check they don't hassle us about somebody saying, "Oh, this person could also be Italian or something like that," and get a passport there or some crap like that.
Well, not to give the USCIS listeners of your show any ideas, but you read this Islam v. DHS case and what the BNP has done since the 80s and the 90s and 2000s. Not condoning political violence. It happens, but happens all over the world. I mean, hell, January 6th in America, but I'm not saying we're the BNP, but it happens in a lot of countries. I bet it happens in Venezuela. I mean, and it was bad in this case, but I don't think it was any worse than in many countries in this world. And if that's material support of terrorism, got a lot of terrorists.
Yeah. Well, on that note, good seeing you in this beginning of June. We'll probably get together again July, and you got your wedding coming up. We might miss an episode here or there. We'll see.
Might miss August. We'll see.
Okay, well, it's not bad. Have a good break. Have you set up the plans for a honeymoon yet?
Yeah, we're going to head out to South Africa the day after.
Wow.
I know. Well, we'll be wearing masks, but we're vaccinated, so... But I don't love that South Africa literally has a variant named after South Africa. That's not so great. But
what made you choose South Africa?
Sounded like a good plan. I've never been to Africa. Safari though. That's
nice.
I don't know. There's so much world. Really, the only qualification was we had someplace my fiance and I hadn't been yet.
Well, first off, it's going to be less expensive because people can't really travel as much, so that's good. And secondly, it's South Africa, so it's winter over there. It's not going to be hot. It's going to be.
I take it back. That was one of the things we wanted to go someplace that wouldn't be too hot in the summer. That is also what it was, and so it had to be south of the equator, way south. That was
Australia's pretty much closed its doors to any visitors. New Zealand too, so those aren't happening. Maybe Argentina would be a fun place, but South Africa, yeah, that's gonna be fun safari and all that. It's a whole different world.
Yeah.
So we're excited. I want to see the pictures. If you see a lion or something like that, or hippopotamus, let me know.
That's right. That's right. I'll get you. You've got those images you make for your podcast where you're in safari gear and stuff.
Yeah.
I'll show them one of them. Do you know this man?
Well, good. So yeah, good talking with you again.
See you, John. I'll have good cases next month. I'll have positive cases.
Yeah, look forward to it. Hopefully, good news. Bye.